G'day everyone and welcome to video 4.1.6 for the Legal Studies guide. This is actually the second iteration or second go at video 4.1.6 after I previously published our video on the Brisbane case, so a High Court case affecting the division of powers. I published it as 4.1.6 and International Declarations and Treaties as 4.1.7 in an absolute inexplicable brain fart by me. I missed the actual 4.1.6, which is about referendums, which we'll do now, and those two have been rebranded as 4.1.7 and 4.1.8. So we'll jump into this referendum video, obviously starting with a quote, and this quote is more for me than you today. Have no fear of perfection, you'll never reach it. Obviously I won't with missing a video, but just a reminder as well that, we're not trying to be perfect, we're just trying to be the best we can. So, as I said, video 4.1.6, the actual 4.1.6, we are looking at the significance of one referendum in which the Australian people have protected or changed the Australian Constitution. Previous study design needed us to know one referendum that impacted the division of powers. This is slightly different, and we could know a referendum that's protected the Constitution or changed. So we can actually look at a referendum that fails if we want, that protects the Constitution, but we are going to look at one that changes the Australian Constitution. This will allow us to analyse the ability of the Australian people to protect or change the Australian Constitution, so what they can and can't do effectively, which we'll look at by looking at an old exam question. So by the end of the day, we're going to be able to answer this. What happened in one referendum involving the changing of the Constitution? Because as I said, we are going to focus on change. The referendum we're going to look at is the 1967 referendum. I'm currently filming this at the start of NAIDOC week, so the 1967 referendum might be mentioned a little bit. Reconciliation week was about a month ago. 1967 referendum was a big part of that as well. It is colloquially known as the Aboriginal People's Referendum. So you could refer to it as the Aboriginal People's Referendum or just 1967 referendum. I'm going to show you what changed first, and then we're going to talk about the significance of this. So prior to 1967, this is what Section 51, Clause 26 of the Commonwealth Constitution said. This obviously intro part, the Commonwealth has the power to make laws for the good order, good governance, whatever of the Commonwealth in regards to, and this was Clause 26. The people of any race other than the Aboriginal race in any state, for whom it is deemed necessary to make special laws, aka the Commonwealth Government can make special laws for the people of any race except Aboriginal people. So they can make special laws for the Japanese, they can make special laws for the Russians, so on and so forth, and we won't go in the minefield of what a race is and racial theory, but the Commonwealth can make a law for any of these specific subsets of people except for Aboriginals. Now the reason for this was, and hopefully most of you have seen an Indigenous map of Australia before with all of the different Indigenous nations. But obviously Aboriginal people in Australia are not all the same. There was hundreds of different Indigenous nations across the country who had different Dreamtime stories, different spiritual beliefs, different languages. It was one of the big factors that differentiated these Indigenous Australians. So when we federated in 1901, it was deemed that the states would have more specific knowledge of the Indigenous people in their own state and should therefore retain the ability to make laws for them. So state is a residual power. Hindsight and history would suggest that this was a poor idea, considering, we won't go into it too much, but some of the stuff the states had done previously and then continued to do throughout the 1900s around the mistreatment and some would say genocide of Indigenous peoples. But nonetheless, in 1901, the Constitution left this responsibility to the states. After the 1967 referendum, that section was removed. So it became that the Commonwealth has the power to make laws for the people of any race for for whom it is deemed necessary to make special laws. Now, some people would argue that perhaps this whole section of the Constitution should have gone completely. Maybe the Commonwealth shouldn't be able to make laws that discriminate against people based on race, or so on and so forth. But it just removed the section other than the Aboriginal race. So what it did was it took the ability to make laws for Aboriginals away from the states and gave it to the Commonwealth. So it removed the restriction that the Commonwealth had on them previously. And we're going to look at the impact of that and what that means. There was also this section in the Constitution, 127, in reckoning the numbers of people of the Commonwealth or of a state, Aboriginal natives should not be counted. So basically Indigenous people didn't count in the census. They didn't count towards Australia's population. And this was completely removed. So the Constitution no longer has section 127. We'll talk about the impact and significance of that. So the impact. And I actually haven't put pictures in this because I'm trying to sort of roll it out quickly. So this is just a stock picture, nothing to do with what we're talking about. The 1967 referendum, though, was the most successful referendum in Australia's history. 91% of voters voted yes, which is really, really significant considering only 8 of 44 referendums have actually passed. And every state, so 6 out of 6 states voted yes as well, a majority in 6 out of 6 states. Basically what it meant was the Commonwealth could now legislate for Indigenous peoples, as we said. They could make specific laws for Indigenous Australians, and it allowed the Commonwealth to start directing funds towards Aboriginal affairs. Previously, states would have had to fund this themselves, and we know the states get a lot of their funding from the Commonwealth government based on population and that sort of thing, but they couldn't actually receive equal share of funding because of not being counted, Aboriginal people not being counted in the census. Meant they didn't get representation if they had a large Indigenous population, because the House of Reps is obviously based on population. So all of a sudden the Commonwealth can direct funds to Aboriginal affairs. It allowed them to set up an Aboriginal affairs portfolio. It allows us to have an Aboriginal affairs minister, which I'm not sure who it is currently, but when Tony Abbott was the Prime Minister, he took on this portfolio himself. Might be Nigel Scullion, I think, is our Indigenous Affairs Minister, and allows them to then basically pass Indigenous housing reforms, health reforms, education reforms, allows them to have a national strategy like the Closing the Gap strategy and the Reconciliation strategy, because the Commonwealth can now make laws in that area specifically to support and help Indigenous Australians. So it is significant because of that overwhelming public support, remembering that the dot point asks us to know the significance of one referendum. So that overwhelming support, only 8 of 44 have been successful and 91% of people voted yes. So this is a significant referendum because it did have broad public support. It's significant in that it alters the division of powers. So it takes a residual power and changes it to a concurrent power, which effectively grants more power to the Commonwealth and takes it away from the states. So that's a significant factor in this as well. And this whole idea of allowing Indigenous people to be counted in the census, it's both got a practical application in that Indigenous people now count towards we've looked at section 24 about the House of Reps. So Indigenous people now factor into the equation of dividing each state's population and working out how many seats they get in the House of Reps. But it also just rights that moral wrong. The idea that Indigenous people were classified at one point as fauna. They were considered animals. They shouldn't count towards our population because they are not human. They are some form of subhuman species. So allowing them to be counted in the population, and it sounds horrible to say that, allowing someone to be counted in the population like there's actually a choice there. But counting Indigenous people in the population by removing section 127 is significant because it rights that moral wrong. It recognises them as people, as members of our country who count towards our population, which is really important. The skill is analyse the ability of the Australian people to protect or change the Constitution. Now, this is slightly different to the skill in the past study design, but we are going to look at a question from the past study design and then look at the examiner's report and use that to sort of build our knowledge in relation to this skill. So This is a question from the previous study design 2013 exam. Using one successful referendum and one High Court case, analyse the impact of referendums and the High Court's interpretation of the Constitution on the division of lawmaking powers. So it was all about how it impacted the division of lawmaking powers. So obviously, two parts to this question, High Court case and referendum. So if we cut it down to 4 marks and we remove the High Court references, using one successful referendum, analyse the impact of referendums on the division of lawmaking powers. So how have referendums impacted the lawmaking powers, the division of lawmaking powers? Slightly different to the ability of the Australian people to change the Constitution, but what the examiners said is going to actually help us understand that. So if we're analysing, here's the skill again, if we're analysing the ability of the Australian people to protect or change the Australian Constitution, we are looking at whether they can or can't effectively. So can they protect it easily and change it easily, or can't they protect it or change it easily? And the study design and this examiner's report gives us some really, really good content for that. First of all, referendums rarely occur. Okay? When they do, they're rarely successful, and they're rarely successful because people don't understand them. People are unlikely to want change. People might vote on party lines, or they might be confused. So can Australia's people protect or change the Constitution? Well, we could say they can't because referendums are rare. And when they're rare, we can't really, or we're not good at changing it because there is generally a lack of understanding. ... So again, we can pull out from the old study design and the old examiner's report some stuff that helps us with this new skill. Many referendums have nothing to do with lawmaking powers. That is all about that old study design about division of powers. Commonwealth has increased its power, not necessarily relevant to what we're doing. Again, they are expensive and time consuming. Therefore, we're unlikely to have them. Expensive. You've got to get everyone in the country to vote. Think about how much money that would cost and how much time that would take. The Parliament generally just prefers to pass laws themselves without changing the Constitution. And generally only uncontroversial referendums or those with strong community support will pass. So if we're talking about protection, we're talking about protected through double majority, meaning there must be broad public support. But also the fact that if there's enough political pressure that we can get a referendum to happen, I suppose, because you've got to wait on politicians. So that's a can't aspect of it. Politicians must approve first. But the can is we elect politicians. So this whole idea of we can change the Constitution because we get a vote, that we elect the politicians who decide if we have a referendum or not, and the Constitution is well protected through things like double majority. However, we can't really change the Constitution because referendums are rare. There's generally a lack of understanding when they happen, and they're expensive. And we can't protect the Constitution as well as we'd like because politicians must approve it first, and often they just pass their own laws that don't actually end up going to a referendum or don't end up changing the Constitution. There's also just some info about this referendum that we just looked at that you might want to look at to build your notes. This is exactly what examiners have said they want. It tells you what the changes are, tells you what the consequences are, and how it changed the division of lawmaking powers. There is a video on a few other different referendums you can find here. I'll put it in the comments. It's the same as the videos on the High Court cases through the Engage Education Wiki. I recommend having a look at it. Pretty simple and easy to follow. But to finish up, hopefully, and the skill was a little bit confusing, I know, but we are looking at analysing, so can they or can't they protect or change the Constitution? Hopefully you can tell us what happened in one referendum involving the changing of the Constitution. This has been video 4.1.6, the real 4.1.6, and I apologise for any confusion with the other two. As always, give some feedback. Feedback's incredibly helpful. That's why I realised that the referendum video wasn't done. So definitely get in touch if you've got any questions, want some changes or want some things done differently, and we'll see what we can do. This has been the Legal Studies Guy. I hope you're all having a fantastic holidays and fantastic study time.